The discovery phase of a car accident case. As soon as your car accident lawsuit is ready to be heard in court, your case will then enter the pre-trial stage. This stage is known as the discovery phase. As in most civil lawsuits, the discovery phase of a claim refers to the period of time when the parties who are involved in the slip and fall claim learn as much as they can about the car accident. A discovery phase can last as little as a few months, or as much as a few years, depending on how complex the case is, and how busy the court is. If the court has a lot of pending lawsuits, it may be that the discovery phase lasts longer than was planned. The interrogatory stage. This stage involves both parties answering questions under oath. During the interrogatories, your attorney will submit some questions to the other party in a bid to learn more about where your accident took place. The other party, if it is suspected they are at fault, will be represented by a defense lawyer who will submit questions so that they can learn whether you were paying attention to the road and other vehicles. The defense lawyer may also ask if you have any physical illnesses or conditions that could make it more likely that you were going to have an accident. You should expect to be asked about your medical history, as it may be relevant to your claim. Requests for production of documents. Requests for production are written requests that ask for documents that could be related to your claim. For example, your attorney may ask for surveillance footage of the area surrounding the scene of the accident. They may also ask for incident reports or police that detail your accident. Medical records. A defense lawyer may ask for your medical records, specifically those that show any treatment you received after the accident. This can be valuable as the medical records will show your injuries in addition to your doctor's opinion of how bad the injuries are. The defense lawyer will also be interested in your medical history, especially if it contains evidence that you have a history of blurred vision, epilepsy, fainting, high blood pressure, muscular disorders, brain disorders, diabetes, dizzy spells, and if you have a history of car accidents. Depositions. Depositions involve lawyers asking witnesses questions, and these questions are asked under oath. The other party's lawyer may ask you, "Do you know what caused the accident? What precautions did you take to avoid the accident? Which part of your vehicle came into contact with the other vehicle first? Do you need to wear prescription glasses? What was the weather like at the time of the accident? Were you distracted while you were driving? Where was your cell phone at the time of the accident? What did you do right after the accident? What medical treatment did you receive as a result of the car accident? Do you still have injuries?" Although quite challenging, you should do your best to answer all of the questions you are asked during the deposition. The defense lawyer will ask you many questions, including some that may not appear relevant. Stick with it, and do your best to answer the questions. The medical examination. If your injuries are disputed, the defense lawyer may insist that you have a medical examination that's undertaken by an independent party. The doctor carrying out the examination will be paid by the other driver's lawyer to examine you and evaluate all of your injuries. If you think you may be asked to undergo a medical examination, it's important that do not exaggerate any injuries. If you do not have any injuries even though you claim you have, you could lose the case.